got into this a little bit before. I think it's important to recognize that the next scientific discovery may come from anywhere. You don't really know where. And I believe that institutions that do not historically have high success rates for NIH grants can contribute to biomedical research and so forth. And I believe we need to give these institutions an opportunity. As we discussed before, Dr. Collins, the eligibility criteria for the IDEA program is outdated. Some of us believe it's outdated. Both the 2012 and 13 Senate Labor HHS bills included report language regarding this issue. However, it's my understanding that no significant information on the subject has ever been provided to the subcommittee as yet. Dr. Collins, could you work with us to develop something on better criteria, eligibility criteria for some of these institutions that really could contribute, you know, if given a chance?
So, Senator, I know time is short, but I'll answer quickly. I do agree that there's wonderful opportunity for capacity building in this competitive program that is known by the name of IDEA. The Institute of Medicine has been undertaking a study of whether the criteria for IDEA and EPSCoR are, in fact, in need of revision, and we expect that report to be released fairly soon. And there'll be a good time then to have a conversation with you and others about this issue.
Let's talk about, if we could, the breakthroughs and the research that's been done in cystic fibrosis over the years. We've talked about this before, and there's been some breakthroughs there. Would you highlight some of them and how we're doing in that area?
It's an area of enormous excitement. My own research lab back in 1989 played a role in collaborating with another group in Toronto in discovering the gene for cystic fibrosis. And now, just in the last couple of years, the really exciting fruits of that in terms of drug therapy have emerged, with one drug called Kalydeco, now approved in record time by the FDA, which shows dramatic responses from individuals who have a particular misspelling of that cystic fibrosis gene. Unfortunately, only about 4 or 5% of cystic fibrosis patients are in that category. But there's great excitement because of phase 2 and phase 3 trials now being conducted by Vertex on 2 new compounds, which should be actually quite useful for 90% or more of people with cystic fibrosis. This all builds upon NIH research that's been done over the decades. It's a wonderful collaboration with the Cystic Fibrosis Foundation, an interaction with a company called Vertex. The Heart, Lung, and Blood Institute, which Dr. Gibbons directs, has funded a lot of this effort through the years. It is a great success story and one that we hope to replicate for lots of other diseases.
Thank you for sharing it with us.
Thank
you, Mr. Chairman.
Senator Cochran.
Mr. Chairman, I'm pleased to join you in welcoming our distinguished panel of witnesses today. Dr. Collins, we appreciate your being here again and also coming out into the countryside where we live and work.
I enjoy that very much, Senator.
We appreciated the honor of your visit to Mississippi, and it might interest you to know that just recently there was an announcement from the Blair Batson Hospital for Children in Jackson, Mississippi, where you were, by Dr. Hannah Gay, who reported a functional cure of a child who was born HIV positive. And this is news that's getting around the world now and is attracting attention again to the distinction that Mississippi has for people like Dr. Arthur Guyton, who wrote many of your textbooks, and others who have pioneered in research in different areas. So we look forward to supporting the work that you do, and we hope we'll be able to provide some seed money or incentive grant funding to ensure that we continue to embark upon daring and innovative approaches to dealing with our health problems in America. Thank you.
Senator Boozman.
Thank you all, and thank you for being here. And I really do want to compliment you all as a group. You all have, your efforts, your work, your advocacy really has changed the world. And we appreciate your efforts very, very much. There's a lot of things that the government possibly, we could argue, doesn't need to be doing. I think, what you all represent is something, the state of Arkansas our communities can't do individually.
I'd like to take this opportunity that I have before to do two things. One thing that will be a business for later on today on Judge Orrick, speak on that nomination, and then I would like to speak on another matter. I rise in opposition to Mr. Orrick's nomination to be District Judge, Northern District, California. And so I'll explain my vote to my colleagues. Before I discuss the nomination, I usually update my colleagues on where we stand on judicial nominations. Thus far, the Senate has confirmed 182 district and circuit court nominees. We have defeated 2 in the United States Senate, so we have a record of passing of the presidential nominees for judgeships, 187, and not allowing 2 to go forward. That's an average of about 989 approval rating. I think it's pretty good indication that the Senate's doing its job and not stopping nominees from moving forward. So far this year, the Senate has confirmed 16 of those 180-some nominees that I just spoke about. Today, if Mr. Orrick is confirmed, we will confirm the 17th nominee this year. At this stage in President Bush's second term, so I'm comparing that second term to President Obama's second term, during President Bush's second term, only 4 were confirmed. So we have approved 17 in a comparable period of time for President Obama, whereas there were only 4 approved for President Bush by this time. This president is, I think, being treated fairly as the Senate should be treating the president. The president has recently submitted a few more nominees that are new names to the Senate. I know that I've been reminding him in speeches like this in the past that we can't do anything about vacancies without the Senate first, or the President first, sending up nominees. But again, even if the recent nominations, even with these recent nominations that the President has hurried up here, we still have 61 of 85 nominations that we have no names from the White House. So nearly 3 out of every 4 vacancies of federal judges in the United States, there's no nominee for us to work with. So again, I urge the President to get those names up here. And for judicial emergencies, which ought to have our prior consideration, only 8 of 35 of those emergency seats have a nominee. So I just wanted to set the record straight. Again, I will be voting no on Mr. Orrick's nomination. He will pass the Senate, I'm sure, regardless of my vote. And this reason, I was troubled by his intervention in Utah, Arizona, South Carolina, and Alabama. In those states, he led the effort to strike down the statutes in those states addressing the federal government's failure to enforce immigration laws. We're in the middle of marking up a comprehensive immigration bill. It is clear that enforcement is a problem. I and some of my colleagues would like to strengthen enforcement, but Mr. Orrick was out there leading the effort to maintain the weak status quo. I don't know why that should lead to a lifetime appointment to the federal bench. I was also disappointed in Mr. Orrick's responses to many of my questions, both addressed at the hearing and in follow-up questions that I submitted for his answer in writing. At his hearing, I asked him a number of questions that he said he couldn't answer at the hearing, but he would familiarize himself with the issues, and I offered to submit those questions in writing to provide Mr. Orrick the opportunity to answer them, a courtesy this committee commonly extends. After granting Mr. Orrick the courtesy, I was disappointed that he still failed to answer many of my questions. So I extended the courtesy a second time, offering Mr. Orrick the opportunity to provide a responsive answer. Unfortunately, the answers he provided to my second set of questions were non-answers. Now I understand that this is not unusual for nominees to claim that they're unable to answer a particular question, but I must say that the degree of Mr. Orrick's non-responsiveness rose to the level well above what's typically the case with nominees. So the rest of my statement I'm going to put in the record on this nominee, and I'm going to urge my colleagues to vote no, but I assume that he will be approved. I want to take a few minutes, longer than I just did on that judge, to discuss the President's nominee for Secretary of Labor, Tom Perez. Mr. Perez is not unknown to the United States Senate, or you might say to the country as a whole, now that he's been Assistant Attorney General for a long time. His tenure as head of the Civil Rights Division has been marked by controversy, and that is, in my words, putting it pretty mildly. He was confirmed to his current post of Civil Rights Division Assistant Attorney General by a vote of 72 to 22. I was among those who supported his nomination to lead the Civil Rights Division. So I have voted for this person once already. But unfortunately, based on the reasons that I'll outline, I have come to regret that vote. There are a number of issues about Mr. Perez's record that should give my colleagues pause. But today I want to focus on the investigation I've been conducting with my colleague in the House, Mr. Issa, Chairman of the Oversight and Governmental Affairs Committee in that other body, as well as Mr. Goodlatte, Chairman of the House Judiciary Committee. I want to share with my colleagues the role that Mr. Perez played in the quid pro quo between the city of St. Paul, Minnesota, and the Department of Justice here in Washington, where the department here agreed not to join two false claims cases in exchange for the city of St. Paul withdrawing its case from the Supreme Court in a case called Magner versus Gallagher. Mr. Perez's actions in this case are extremely troubling for a number of reasons. In other words, if an individual takes extraordinary action to get a city to withdraw a case that's already on the docket of the Supreme Court, that's pretty serious intervention. First and foremost, at this point, no one disputes this point, the fact that Mr. Perez orchestrated the entire arrangement. He manipulated the Supreme Court docket so that his favored legal theory, called disparate impact theory, would evade review by the High Court. In the process, Mr. Perez left a whistleblower twisting in the wind. Those are the facts, and even Mr. Perez doesn't dispute those facts. The fact that Mr. Perez struck a deal that potentially squandered up to $200 million taxpayers' dollars in order to preserve the disparate impact theory that he favored is, of course, extremely troubling in and of itself. But in addition to the underlying quid pro quo, the evidence uncovered in our investigation revealed Mr. Perez sought to cover up the fact that the exchange even took place. And finally, let me emphasize that this should concern all of my colleagues. When Mr. Perez testified under oath about this case, both to congressional investigators and during his confirmation hearing, Mr. Perez told yet a different story. The simple but unavoidable conclusion is that the story Mr. Perez told is simply not supported by the evidence. So I will start by reviewing the underlying quid pro quo. In the fall of 2011, the Department of Justice was poised to join a False Claims Act lawsuit against the city of St. Paul. The career lawyers, when I use the word career lawyers, these folks are not political appointees. The career lawyers in the U.S. Department or U.S. Attorney's Office in Minnesota were recommending that the Department of Justice join this false claims case. The career lawyers, even in the civil division at Maine Justice, were recommending that Justice join the case. And the career lawyers in the Department of Housing and Urban Development were also recommending that the Department of Justice join in this false claims case. And why is that important? Because the government participating in a false claims case makes that a better case than just the individual that brings it. But this was all, what I just described to you was all before Mr. Perez got involved. At about the same time, the Supreme Court agreed to hear the case called Magner versus Gallagher. In Magner, the city of St. Paul was challenging the use of the disparate impact theory under the Fair Housing Act. The disparate impact theory is a mechanism Mr. Perez and the Civil Rights Division have been using in lawsuits against banks for their lending practices. If that theory were undermined by the Supreme Court, it would likely spell trouble for Mr. Perez's lawsuits against the banks. So Mr. Perez approached the lawyers handling the Magner case, and he cut a deal. The Department of Justice agreed not to join two false claims cases in exchange for the city of St. Paul withdrawing Magner from the Supreme Court. In early February 2012, Mr. Perez even flew to St. Paul to finalize the deal. The next week, the Department of Justice declined the first false claim case called the Newell case. The next day, the city of St. Paul withdrew the Magner case from the Supreme Court. So everybody thought the deal was settled. Now there are a couple aspects about this deal that I want to emphasize. First, as I mentioned, the evidence makes clear that Mr. Perez took steps to cover up the fact that he had bartered away the false claims cases. Cover-ups aren't good in government. On January the 10th, 2012, Mr. Perez called the line attorney in the U.S. Attorney's Office regarding the declining memo in the Newell case. Just to remind my colleagues, Newell was the case the same career attorneys were strongly recommending the United States join before Mr. Perez got involved. By the time of this phone call in January 2012, Mr. Perez was well on his way towards orchestrating this quid pro quo that I have described. So Mr. Perez then called the line attorney, Mr. Greg Brooker, and instructed him not to discuss the Magner case in the memo that he prepared outlining the reasons for the decision not to join that false claims case. And here's what he said. "Hey, Greg," this is a quote, "Hey, Greg, this is Tom Perez calling you at 9 o'clock on Tuesday. I got your message. The main thing I wanted to ask you, I spoke to some folks in the civil division yesterday and wanted to make sure that the declination memo that you sent to the civil division, and I'm sure it probably already does this, but it doesn't make any mention of the Magner case. It is just a memo on the merits of the two cases that are under review in the Ketam context." End of that conversation. Now, approximately 1 hour later, Mr. Perez sent Mr. Brooker's follow-up email writing, quote, "I left you a detailed voice message. Call me if you can after you have a chance to review the voicemail." End of quote. Several hours later, Mr. Perez sent another follow-up email, quote, Were you able to listen to my message, end of quote. Now, Mr. Perez's voicemail was quite clear and obvious. He told Mr. Brooks, make sure that the declination memo doesn't make any mention of the Magner case. It is just a memo on the merits of the two cases, end of quote. Now, what could be more clear than that? In fact, Mr. Perez himself sent an email less than an hour later explaining that he had left a detailed voicemail for Mr. Brooker. Yet, when congressional investigators asked Mr. Perez why he left the voicemail, he told an entirely different story. Here's what he told the investigators, quote, what I mean to communicate was, it is time to bring this to closure. And if the only issue that is standing in the way of how you talk about Magner, then don't talk about it. End of quote. Well, I hope you're listening and you say to yourself, give me a break. This is just plainly not what he said in his voicemail. Mr. Perez, I was born at night, but I wasn't born last night. He didn't say anything about being concerned with the delay. He said, quote, make sure you don't mention Magner. It is just a memo on the merits, and that's emphasized, end of quote. His intent was crystal clear. Mr. Perez also testified that Mr. Brooker called him back the next day and refused to omit the discussion of the Magner case that was being withdrawn from the Supreme Court. According to Mr. Perez, he told Mr. Brooker during this call to, quote, unquote, follow the normal process. But again, this story is just not supported by the evidence. 1 month later, after Mr. Perez flew to Minneapolis to personally seal the deal with the city, a line attorney in the civil division emailed his superior to outline, quote, unquote, additional facts about the deal. Point 6 read, U.S. Attorney Minnesota, that's abbreviated here, U.S. Attorney Minnesota, considers it, underlying, non-negotiable that its office will include a discussion of the Supreme Court case and the policy issues in its declination memo, end of quote. If Mr. Perez's story were true and the issue was resolved on January the 11th, then why, 1 month later, would the United States Attorney's Office need to emphatically state that it would not hide the fact that the exchange took place? Thank God for honest line attorneys, career attorneys. Now, as I just mentioned, Mr. Perez flew to Minneapolis to finalize the deal on February the 3rd. And you would think that a deal of this magnitude would be memorialized in a detailed written agreement. After all, you can't even rent a car without signing a detailed agreement. But was this agreement written down? No, it wasn't. After Mr. Perez finalized the deal, the career attorney asked if there was going to be a written agreement. What was Mr. Perez's response? He said, quote, no, just oral discussions. Word was your bond, end of quote. Now, once again, the people listening to this are probably saying to themselves, can you believe that? Here is Mr. Perez. He has just orchestrated a deal where the United States declined to join a case worth up to $200 million to the federal treasury in exchange for the city of St. Paul withdrawing a case from the Supreme Court. And when the career lawyers ask if this deal will be written down, he says, no, your no word was your bond. Now, as everyone knows, the reason you make arrangements like this in writing is so that there's no disagreement down the road about what the parties agreed to. As it turns out, there was, in fact, a disagreement about the terms of this unwritten deal. The lawyer for the city of St. Paul, Mr. Lillyhog, told congressional investigators on January the 9th, approximately 1 month before the deal was finalized, Mr. Perez assured him that HUD would be helpful if the Newell case proceeded after the Department of Justice declined to intervene. Mr. Lillyhog also told investigators that on February 4, the day after they finalized the deal, Mr. Perez told him that HUD had begun assembling information to assist the city in a motion to dismiss the Newell's complaint as original source grounds. But according to Mr. Lillyhog, this assistance disappeared after the lawyers in the civil division learned about it. Now let me tell you the significance of that. Mr. Perez represents the United States. Mr. Newell is bringing a case on behalf of the United States. Mr. Perez is talking to lawyers on the other side, and he tells them, after the United States declines to join the case, we will give you information to help you defeat Mr. Newell, who is bringing the case on behalf of the United States. Mr. Newell, the whistleblower, was left hanging out to dry by Mr. Perez. In effect, Mr. Perez is offering in that statement to give the other side information to help defeat his own client. I recognize this is a significant allegation, and Mr. Perez was asked about it under oath. His response, Mr. Perez said, quote, "No, I don't recall ever suggesting that." So, on the one hand is Mr. Lillyhog, who says Mr. Perez made this offer first in January and then again on February the 4th, but the assistance disappeared after the lawyers in the civil division caught wind of it. On the other hand is Mr. Perez, who testified under oath. I don't recall ever having made that offer. Who should we believe? Well, the documents support Mr. Lillyhog's version of events. On February the 7th, a line attorney sent an email to the Director of Civil Fraud Section and relayed a conversation the Assistant U.S. Attorney in Minnesota had with Mr. Lillyhog. According to Mr. Lillyhog, the line attorney wrote that there were 2 additional items that were part of the deal that is not a deal. And one of those 2 items was this, quote, HUD will provide material to the city in support of their motion to dismiss the original source grounds, end of quote. Internal emails show that when the career lawyers learned of this promise, they strongly disagreed with it, and they conveyed their concerns to Tony West, head of the civil division. During his transcribed interview, Mr. West testified that it would have been inappropriate to provide this material outside of the normal discovery channels. Mr. West said, quote, I just know that that wasn't going to happen, and it didn't happen, end of quote. In other words, it's this simple. When lawyers at the civil division learned of this offer, they shut down that offer. The documentary evidence shows the events transpired exactly as Mr. Lillyhog said they did. Mr. Perez offered to provide the other side with information that would help them defeat whistleblower Newell in his case, and that case was on behalf of the United States and the taxpayers, and possibly $200 million. Well, I imagine that this is simply stunning, the lack of common sense that the American taxpayers hear about this, when they hear about it. Mr. Perez represents the United States. Any lawyer would tell you it is highly inappropriate to offer to help the other side defeat the client. Now, this brings me to my final point. points that I want to highlight for my colleagues. Even though the Department traded away Mr. Newell's case, Mr. Perez has defended his decisions in part by claiming that Mr. Newell still had his day in court. What Mr. Perez admits from his story is that Mr. Newell's case was dismissed precisely because the United States was not a party, no longer a party to it. After the U.S. declined to join the case, the judge dismissed Mr. Newell's case based upon the legal language public disclosure bar, finding he was not, again, legal source, the original source of the information to the government. I want to remind my colleagues that we recently amended the False Claims Act precisely to prevent an outcome like this. Specifically, that amendment made clear that the Justice Department can contest the original source dismissal even if it fails to intervene as it did in this case. So the Department didn't merely decline to intervene, which is bad enough, but in fact it affirmatively chose to leave Mr. Newell all alone in this case that Mr. Newell filed for the benefit of the United States. And of course that is the whole point. That is why it was so important for the city of St. Paul to make sure that the United States did not join the case. That is why the city was willing to trade away a strong case before the Supreme Court. The city knew that if the United States joined the action, the case would almost certainly go forward. Conversely, the city knew that if the United States did not join the case and chose not to contest the original source, it would likely get dismissed. Now think about that a while. $200 million possibly down the drain. The Department trades away a case worth millions of taxpayers' dollars. They did it precisely because of the impact the decision would have on the litigation. They knew that as a result of their decision, the whistleblower would get dismissed based upon original source grounds since they didn't contest it. And not only that, Mr. Perez went so far as to offer to provide documents to the other side that would help them defeat Mr. Newell in his case on behalf of Mr. Perez's client. Again, that client was the United States. And yet when the Congress starts asking questions, they have the guts to say, quote, "We didn't do anything improper because Mr. Newell still had his day in court," end of quote. Well, he should have had his day in court and probably would have if they hadn't cut the limbs out from under him. Now, this brings me to my last point, and that has to do with the strength of the case. Throughout our investigation, the Department has tried to defend Mr. Perez's actions by claiming the case was marginal or weak. Once again, the documents tell a far different story. Before Mr. Perez got involved, the career lawyers, again, not political appointees, but career lawyers at the Department, wrote a memo recommending intervention in the case. In that memo, they described St. Paul's actions as, quote, "a particularly egregious example of false certification," end of quote. In fact, the career lawyers in Minnesota felt so strongly about the case that they took the unusual steps of flying here to Washington, D.C. to meet with HUD officials. And HUD, of course, agreed that the United States should intervene. But that was before Mr. Perez got involved in the case. The documents make clear that career lawyers considered this a strong case, but the Department has claimed that Mike Hertz, the Department's expert on False Claims Act, considered it a weak case. In fact, 2 weeks ago, Mr. Perez testified before my colleagues in the Senate Health Committee that Mr. Hertz, quote, "had a very immediate and visceral reaction that this was a weak case." But what do the documents show? They tell a different story. Mr. Hertz knew about the case in November 2011. 2 months later, a Department official took notes of a meeting where the quid pro quo was discussed that official wrote down Mr. Hertz's reaction. This official wrote, quote, Mike, referring to Mr. Hertz, Mike, odd, looks like buying off St. Paul. Should be whether there is a legit reason to decline as to past practice, end of quote. The next day, that same official emailed the Associate Attorney General here in town and said, quote, Mike Hertz brought up the St. Paul disparate impact case in which the Solicitor General just filed an amicus brief in the Supreme Court. He's concerned about the recommendation that we decline to intervene in 2 key cam cases against St. Paul, end of quote. So you got these documents appearing to show that Mr. Hertz's primary concern was not the strength of the case, as Mr. Perez led Senate colleagues to believe. Mr. Hertz was concerned the quid pro quo Mr. Perez ultimately arranged was, in fact, improper. And again, in his words, it, quote, looks like buying off St. Paul, end of quote. And just last week, the Justice Department sent my staff a critical 33-page slide showing the department's case against St. Paul. In that document, the career lawyers made their strong case for intervention, Justice Department to intervene with Newell to bring this case about. The department failed to provide this critical document to the committees, and we only learned about this document not from the Department of Justice, but from a recent interview we had with HUD employee. Why do I say that this is a critical document? Because this document makes abundantly clear that career lawyers did not view this case as marginal, that Mr. Perez wants you to believe that other people in the department, experts on false claims, thought it was a marginal or weak case. And obviously, he didn't view it as a weak case, as Mr. Perez testified before the Help Committee. Far from it. Here is how the career lawyers summed up the case in one of the final slides of this document. Now, these are quotes. The city repeatedly and knowingly misrepresented its compliance with Section 3 of the to obtain federal funds. Tentative conclusions. The city has long been aware of its obligation under Section 3. The city repeatedly told HUD and others that it was in compliance with Section 3. The city has failed to substantially comply with Section 3, end of quote. Does that sound like career lawyers describing a marginal or a weak case? Of course not. Yet that is what Mr. Perez told my colleagues on the Help Committee. Mr. President, my colleagues are well aware of how I feel about the Whistleblower Protection Act. And my colleagues know how I feel about protecting whistleblowers who have the courage to step forward, often at great risk to their own careers. But this is about much more than the whistleblower who was left dangling by Mr. Perez. This is about the fact that Mr. Perez manipulated the rule of law in order to get a case removed from the Supreme Court docket. But most importantly, this is about the fact that when Congress started asking questions about this case, and when Mr. Perez was called upon to offer his testimony under oath, he chose to tell an entirely different story. And the unavoidable conclusion is that that story he told is flatly not supported by the facts. We have to demand more. We have to demand that when individuals are called upon to answer questions before the Senate, that they shoot straight, regardless of the consequences. I do not believe that Mr. Perez gave us the straight story when he was called upon to answer questions about this case, and for that reason, I recommend, first of all, that my colleagues study these issues. And there's others that are going on right now between Holder, Attorney General Holder, and the House Government Oversight Committee, as he's there today. There's a lot in this that needs to be brought out about this nomination before we vote on it. And this evidence I give you is just part of the story. Thank you, and I yield the floor.
Mr. President.
The senator from Utah.
Mr. President, I rise today to speak in support of the nomination of Marilyn Tavenner to serve as Administrator of the Centers for Medicare and Medicaid Services, or CMS, one of the largest agencies ever in the history of the country. For a number of reasons, CMS has been without a confirmed administrator since the fall of 2006. CMS is the world's largest insurer. It processes over 1 billion Medicare and Medicaid claims a year and has a budget of nearly $1 trillion. It also provides services to over 100 million of our nation's most vulnerable citizens receiving Medicare and Medicaid. So clearly this is a critical agency that needs a strong leader at the helm. Thus far from what I've seen, Ms. Tavenner has the qualifications to be that kind of a leader. I believe her to be. She has clinical experience from being a nurse, executive experience from being, from serving as a hospital administrator, and hands-on operational experience from her time as Secretary of Health and Human Resources for the state of Virginia. That rare combination of skills will be essential when heading an agency as diverse as CMS. There is a reason she was voted out of the Senate Finance Committee on a voice vote and had the House Majority Leader come testify in her behalf. Starting in 2010, she was appointed as the Deputy Administrator of CMS. And since November of 2011, she has served as the Acting Administrator. So far, she's shown a willingness to work with members of both parties, which is a welcome development, particularly under this administration. At a time when the Secretary of the Department of Health and Human Services is engaging in activities that are less than transparent and potentially illegal, it is even more important that an agency as vital as CMS be headed by someone with strong ethics and integrity. Make no mistake, this agency's greatest challenges lie ahead. One of the biggest problems facing CMS in the near future is implementation of the federal and state-based health insurance exchanges established under Obamacare. These exchanges are supposed to be brought online later this year, but there are numerous obstacles that will have to be addressed. By most indications, it would take a miracle for the exchanges to be up and ready on time. To date, CMS has not been able to provide satisfactory answers to a number of questions posed by myself and other members of Congress regarding the exchanges. For example, we have yet to see a breakdown of the budget for the federally facilitated exchange. Furthermore, we still know very little about the operational details of the exchanges and even less about how people will enroll. These are serious issues, Mr. President, and with this system you are asking American families to entrust the fate of their health care services to the empty words and deeds of an administration that has repeatedly shown a complete inability to be held accountable. More importantly, with the recent revelations of potentially criminal behavior at the Internal Revenue Service, I am very concerned about trusting that agency's ability to work with CMS and HHS to deliver benefits for Americans through the exchanges. Almost every day, we see new indications that the health law is an unmitigated disaster. We are already seeing evidence that health insurance premium costs are continuing to rise and are projected to be, on average, 32% higher than the individual market. At the same time, according to the numbers released yesterday by the Congressional Budget Office, by 2019, almost 14 million Americans who would have employer-provided coverage will no longer have it. Let me be very clear. Obamacare is fundamentally flawed. The only real way to fix it is to repeal it and then start again. But until we can accomplish that goal, we need to make sure that we're protecting our fellow citizens the best we can from all of the negative effects of this law. In addition to overseeing this massive new expansion of benefits, Ms. Tavenner will also be charged with helping to ensure the longevity and solvency of the existing Medicare trust fund, which is projected to go bankrupt in 2024. All told, between now and 2030, 76 million baby boomers will become eligible for Medicare. Even factoring in deaths over that period, the program will grow from approximately 47 million beneficiaries today to roughly 80 million beneficiaries in 2030. Maintaining the solvency of the Medicare program while continuing to provide care for an ever-increasing beneficiary base is going to require courageous solutions. I've had several conversations with Ms. Tavenner about the need for structural entitlement reform to ensure that these programs are here for future generations. I sincerely hope that we will continue to make progress on these critical issues. Overseeing a massive bureaucracy like the one at CMS is not a job for the faint of heart. I will be keeping a close eye on Ms. Tavenner as she takes the reins. If she is to be successful, she'll have to realize that she can't do it alone. She will have to work with members of Congress from both parties. I hope that she will do so. I believe that she will. Thus far, I have reason to believe that she will be one of the best leaders we can possibly have in the government. However, if under her leadership CMS continues what has become a disappointing pattern in this administration, not responding to legitimate congressional inquiries and throwing promises of transparency by the wayside, I will use my full weight of my position as the ranking member on the Senate Finance Committee to hold her and others fully accountable. I don't think I'm going to have to do that. I actually think she's that good. Mr. President, I appreciate Ms. Tavenner's willingness to serve in this difficult position. And while I still have many concerns about the policies of this administration and the direction CMS is heading, I plan to vote in favor of her confirmation because she has the ability and potential to be a real leader and already has exemplified that in many ways. And I encourage my colleagues to vote for her. I think Marilyn Tavenner is the right prescription at the right time to help with HHS and also with CMS, which is, like I say, one of the largest agencies ever in the history of the country and of the world. She's a good woman. She's dedicated. She has the ability. And I believe that she will do a great job. With that, I yield the floor.
Senator from Virginia, senior senator from Virginia is recognized.
Mr. President, I want to first of all commend my friend, the senator from Utah, for his comments. We all know the senator from Utah who, like myself, has a real interest in making sure that our government is more efficient and more effective in its operations, and know as well that the senator from Utah has not always been necessarily supportive of the health care reform, the Affordable Care Act. But I really want to appreciate the senator from Utah's comments about Marilyn Tavenner. I've known Marilyn Tavenner for 25 years, and I think while we may disagree about the effectiveness of the Affordable Care Act, we do know one thing. We want CMS to be the most efficient, effective organization possible. And I really want to commend the senator from Utah for his strong endorsement of Marilyn Tavenner. I think he spoke eloquently about her background, and I'm going to try to add a few comments, but I didn't want him to get away without my thanking him for his comments. So, Mr. President, I am rise today to join this bipartisan show of support for the President's nominee to lead the Center for Medicare and Medicaid Services, Marilyn Tavenner. She comes to the floor this afternoon on a fairly unusual circumstance, considering some of the nominees we are considering. She came actually with a unanimous voice vote from the Senate Finance Committee. She is supported by a number of healthcare organizations and professionals, including the American Hospital Association, the SEIU, the American Nurses Association, just to name a few. As I mentioned already, I've known Marilyn Tavenner for 25 years. She's the real deal, and she will be a phenomenal choice to continue to lead CMS. Marilyn grew up in a small town in Southside, Virginia, and worked her way through school. She began her career in health care, not as a hospital administrator or an executive, but she began on the front lines as an emergency room nurse. But then, through her ability and ability to relate to people and care, she rose to become CEO of a hospital and then a senior executive of a leading healthcare company. I know as governor, I called upon Marilyn on a repeated basis on healthcare issues that affected Virginia. Marilyn has always been committed to people and public service, and she took that private sector knowledge and experience into the public sector even before her tenure with this administration, when she joined my good friend and the junior senator from Virginia, Tim Kaine, when he became governor, and served with his administration as the Virginia Secretary of Health. Today, Marilyn has already served at the highest levels of CMS, where she's shown her ability to manage and operate one of the largest and most complex agencies in our whole government. By spending most of her career in the private sector, she knows the impact that regulations and rules have on the real world, understands the importance of not just achieving a policy goal, but ensuring that it works in practice. As we all know, passing a law like the ACA is a complicated process, and particularly a law like this that has generated as much controversy. That means the role of the administrator of CMS to be even-handed, fact-based, effective, and efficient in implementing the dramatic transformation of the healthcare market that the ACA is going to provide will require a first-class administrator, somebody who understands how to get things done, and somebody who is well-respected by both sides of the aisle. Marilyn Tavenner clearly fits that bill. She is held in extraordinarily high esteem. We've again heard the ranking member on the Finance Committee already speak in support of her. She received unanimous support from the Finance Committee, but she's also held in extraordinarily high esteem by her peers. Matter of fact, in February, all of the previous living Senate-confirmed administrators of the CMS, Democrats, Republicans, Independents, all of them who've run the organization agency in the past, all sent a letter urging her confirmation, noting, quote, "It was hard to imagine a candidate more worthy of bipartisan support." So I look forward to voting with, I hope, which will be an overwhelming majority of my colleagues, to confirm Marilyn for this very important role a little bit later this afternoon. And I know I'm about to give up my time and yield to a great new senator from Massachusetts, and I know she's going to be speaking about another nominee, someone who I've had the opportunity to visit with a couple of times in a role that may be almost as controversial as being head of CMS, being administrator of EPA. And I just want to say in my conversations with Ms. Gina McCarthy, she seems to bring both a breadth of background, work at the state level, working under both Democratic and Republican administrations. And I know that the Senator from Massachusetts is going to speak to her qualifications, but as long as I'm up here, I want to add my voice as well, that I think Ms. McCarthy will be a great head of the EPA, and look forward to joining my friend and colleague, the Senator from Massachusetts, in supporting her. With that, Mr. President, I yield the floor.
Mr. President.
The senior senator from Massachusetts is recognized.
Thank you. I want to start by thanking the senior senator from Virginia. Both for advancing a nomination that we will vote on this afternoon, and for your comments about Gina McCarthy. She is, as you say, a quite remarkable person, and she will be a wonderful director of the Environmental Protection Agency, and I very much appreciate your comments about her, and I know Ms. McCarthy does as well, and the people of Massachusetts do as well. Thank you. I rise today, Mr. President, to do something very simple. I ask my colleagues to give a simple vote to the President's nominee to head the Environmental Protection Agency. This is not fancy or ambitious. It's just a basic principle of good government in our constitutional system. When the founders of our republic came together to write the Constitution, they knew that the President would need help in administering this great and expansive nation. Without help, without a government that was staffed, justice would not be established, our common defense would be threatened, and the blessings of liberty we hope to secure through our laws would go unfulfilled. The founders of our republic gave to the President the task of nominating individuals to serve and gave us the responsibility to advise on and consent to these appointments. For more than 200 years, this process has worked. Presidents over the years have nominated thousands of qualified men and women who are willing to serve in key executive branch positions. The Senate has considered nominations in a timely fashion and taken up or down votes. Of course, there have been bumps along the way, but we have never seen anything like this. Time and again, members of this body have resorted to procedural technicalities and flat-out obstructionism to block qualified nominees. At the moment, there are 85 judicial vacancies in the U.S. courts, some of which are classified as judicial emergencies. That's more than double the number of judicial vacancies at the comparable point during President George W. Bush's second term. And yet, right now, there are 10 nominees awaiting a vote here in the Senate, and they haven't gotten one. But that's not all. The Secretary of Defense's nomination was held up for weeks and then filibustered. The nominee for the Secretary of Labor, Tom Perez, has been held up on an obscure technical maneuver. And then, of course, there is the determined effort to block Richard Cordray to head the Consumer Financial Protection Bureau, not because he is unqualified. In fact, he has received praise from industry and consumer groups alike. And even the Republicans who block him have praised his fairness and his even-handedness. No, Rich Cordray is blocked because some members of this body don't like the agency he heads. They know they don't have the votes to get rid of it or to weaken it, and so instead they are holding the director's nomination hostage. And now we get to Gina McCarthy. This past Thursday, the Senate Environment and Public Works Committee was scheduled to vote on Gina McCarthy's nomination to head the Environmental Protection Agency. Right before the scheduled vote, all the Republicans decided not to show up. Under Senate rules, that meant there was no quorum and that the vote could not take place. The President has done his job. He named an outstanding nominee for the administrator of the Environmental Protection Agency, Gina McCarthy. Gina's dedicated her professional life to the protection of our public health and to the stewardship of our environment. She was confirmed to her previous position at the EPA as Assistant Administrator for Air and Radiation by voice vote without objection. Now, just to be clear, this means that most of the members of this chamber have already voted to approve her once before. Gina also has a long record of working effectively across party lines. She served under Republican and Democratic governors alike, including working for Governor Mitt Romney, the most recent Republican presidential nominee. Her record in Massachusetts was stellar, and she has done all of us in the Commonwealth proud through her service in Washington. Gina herself has also done her job, and more. She has answered a staggering 1,120 questions from the Environment and Public Works Committee. That is the largest number of questions ever asked of a nominee facing Senate confirmation. To put this in some perspective, 4 years ago, when the last confirmed administrator of the EPA, Lisa Jackson, was asked 157 questions during her nomination process. When Congress convened in January, many of us, both veterans and newcomers, were concerned that this kind of obstructionism would persist in the new Congress. We pushed hard for changes to the filibuster rules. We understood the passions on both sides of the issue, and we listened to our colleagues. Ultimately, the two sides reached a compromise that many of us were concerned about, but it included a clear understanding that the Democrats would not make substantial changes to the filibuster, and in return, the Republicans would not abuse its use. But in the past 3 months, abuse has been piled on abuse. Republicans have prevented votes on judges, on agency heads, and on administration secretaries. This is wrong. Republicans can vote no on any nominee they choose, but blocking a vote is nothing more than obstructionism. Blocking the business of government, the business of protecting people from cheating credit card companies or from mercury in the water or from unfair labor practices. This must stop. The President has done his job. Gina McCarthy has done her job. Now it is time for the Senate to do its job. Gina McCarthy deserves a vote. Thank you, Mr. President. I yield.
Senior senator from New Hampshire is recognized.
Thank you, Mr. President. I'm here to join my colleague, Senator Warren, to also express my frustration about what's happening with the nominees to these critical agencies that are being held up by our colleagues on the other side of the aisle. As Senator Warren just said very eloquently, last week, the Republican members of the Senate Environment and Public Works Committee chose not to appear for the important business of